rise. You may be seated. Are we ready? This is the afternoon session of the Kansas Court of Appeals, sitting here in Topeka. I'm echoing. Our first case this afternoon, well, excuse me, I should introduce the panel. No, I'm still echoing. All right. No. Hello? Sometimes technology doesn't work as you anticipate. Hello?
Since we're all 5 feet from each other, I've never understood the purpose of having microphones.
Well, I think they can't record us if we're not going through the microphone for the YouTube. Is that right? Hello? Hello? I don't see any difference. Hello? I think so. Hello? No, that's worse. Hello? Is that better? All right. Again, this is the afternoon session of the Kansas Court of Appeals. Sitting with me today on my right is Judge Tom Malone, and to my left is Judge Catherine Gardner. My name is Kim Schroeder. We have all been on this court for more than 10 years. We're rather experienced. I will tell you that we've read your briefs and know the facts fairly well. Unless there's something specific that you want to tell us, I would not spend a lot of time on the facts. With that, we'll call our first case today. It's State of Kansas versus Roger Lee Dehart. It is case number 125356. Counsel?
Hey, please, Court, Your Honor, Kevin Shepard appearing on behalf of Mr. Dehart, who also appears in person.
May it please the court, the state appears by Deputy District Attorney Jody Litvin.
Thank you, counsel. I think you have 15 minutes.
Yes, and I'd like to reserve 2 minutes for rebuttal.
2?
Yes.
You have it,
Thank you.
and you may proceed.
Thank you.
Well, wait, let's get the timer at the right time.
All right, thank you.
You may, excuse me, you may proceed.
Thank you. Your Honor, as Mr. DeHart's appellate counsel, my biggest concern was looking when I was trying to review this for appeal was to find an appealable issue. When I was looking through it, I didn't have any, and mainly because when Mr. Hoffman was representing Mr. DeHart, he inadequately represented him. And I'm real cautious about trying to file a ineffective assistance of counsel. I've asked for the Van Cleveland man, and I did so with abundance of caution. I really didn't have anything else to really appeal, mostly because the motion to suppress was the main issue that Mr. Hoffman had raised. And when I looked at it, I mean, there was the good faith doctrine was a tough one to overcome, but you couldn't do it without having Trooper Starr available to testify. And I mean, if Trooper Starr was not on the stand, I don't know how you could even overcome that. It's mainly, that motion to suppress, it's got to be couched as a Frank's motion. And it would be on the burden, it would be on Mr. DeHart's burden. It's his burden to actually provide that evidence. And at that initial hearing, the states had Trooper Starr subpoenaed and waiting out in the hall. And for whatever reason, Mr. Hoffman never even called him to the stand. It was imperative that he did do so.
Isn't that when the parties decided to submit it on the briefs?
They did. That was the initial hearing when this case first was presented. And Mr. Hoffman did write in his written brief that the good faith doctrine wouldn't apply, but he never really explained how. And without having any kind of evidence and it being at his burden, there would be no way for the court to even make a ruling in his favor on that issue. But even more important, I mean, I look at this and I step back and I say, okay, wait a minute. Look at Mr. DeHart's case. He had a huge amount of risk hanging over his head with this case. And the very first thing I wanted, which should have been presented was the length of time that it took for the state to even file charges in this case. And I understand where the district court said, okay, well, those cases usually, or those motions are usually get denied based on constitutional speedy trial grounds. That doesn't mean you don't file it, especially in this case.
But now on appeal, when you're talking about ineffective assistance of counsel, isn't it Mr. DeHart's burden to show that that motion would have been successful?
Yes, it is his burden, and I think there still was. There was something that, and I think it was quickly dismissed. And I'm arguing, I'm not just thinking it's quickly dismissed. It was quickly dismissed by the district court, and mainly because it just, maybe it was kind of like an eye roll. Well, we've seen these before. But here, if you look at the facts of this case, February of 2016, he gets arrested and nothing changes. I mean, it's not like the evidence changed or anything like that, but it doesn't get filed until November of 2018.
So that would say 33 months is presumptively prejudicial.
Correct.
But tell me about the other factors that would be in your favor.
Well, again, now we have the fact that Trooper Starr has moved on. We have witnesses that are no longer in the same position. That was a difficulty that, not that Mr. Hoffman still could have subpoenaed him. I mean, he's not that hard to find, but still, I mean, it was more difficult. They couldn't just contact, I know it's a lot easier when they're still working for the Kansas Highway Patrol or any other law enforcement agency to be able to have them.
But didn't the trooper continue to keep his address, I think in Jackson County?
He actually, not in Jackson County, he had it in Jefferson County.
Jefferson County.
Yeah, it was in Jefferson County. And again, I don't understand. This goes again to more the motion to suppress. And I know we were talking about the speedy trial motion. And I understand where you're coming
Well,
from.
they're linked a little bit.
Right, but the fact that he couldn't get Trooper Starr even after the first hearing where he was there waiting in the hall and failed to call him. Later, he wanted to have him called again to see if he could rectify or present the remainder of what he was trying to argue we tried to argue over and over again to the district court that Trooper Starr left off some crucial information out of his affidavit. The fact that he couldn't get him and couldn't have him find, he wasn't found. He was not a secret. It was really easy for me to find him.
You're talking about Trooper Starr.
Yeah, Trooper Starr.
But how did his absence adversely affect your motion to suppress?
Well, not my motion to suppress, or Mr. Hoffman's? How did
Yes,
it, how
yes,
did it
thank you.
affect that? I'm sorry.
Mr. DeHart's, yes.
You know, Mr. Dehart's motion to suppress. When Mr. Dehart, his essential argument was, with the lack of probable cause, is that you still have to get over the good faith doctrine. The good faith doctrine is a tough one to overcome, but to overcome it, you have to show that there was a material omission or some sort of falsehood in the affidavit. Material omissions we have. There in that affidavit, Trooper Starr relayed the information to Judge Debenham, who was the issuing judge for the motion to suppress, or the search warrant of Mr. Dehart's home, that this was an informant, implying that he knew who this person was. That's not, an informant kind of indicates that they had an ongoing relationship. They had no ongoing relationship. That's not ferreted out until I brought him at the ineffective assistance of counsel hearing back in May of 2024.
Well, he was a named informant. He wasn't a confidential informant,
No,
which might imply a course of dealing.
True, he was named, but he was implied that he was some sort of ongoing relationship, that he knew who he was. He didn't know who he was. And the fact that he didn't even know,
Who didn't know?
I'm sorry, the
Trooper?
Trooper Starr did not know who Mr. Breyer was, the person he pulled over.
Until he stopped him.
Right, until he stopped him. It was the first time he ever meets him. Now he meets him, and Mr. Breyer is telling him all about where he gets his methamphetamine, and there's no way for him to know offhand whether that information is correct. He would have to do some sort of investigation, which he didn't do.
Well, what about the fact, I mean, it's true that, there might not be any assumption here that this is a reliable informant, since they had no course of dealing.
Sure.
But what about all the details that were included in the search warrant affidavit that would perhaps give rise to probable cause, like the length of time Mr. Breyer had dealt by buying drugs from your client over a course of years, twice every week? I mean, the details and about it was from the garage and it was at this address. How does that not show probable cause to issue a search warrant?
So if an unverified informant gives you an extraordinary amount of detail and really flowers it up, we're supposed to accept it without any kind of corroboration? And I mean, I don't mean that to be condescending.
Well, there's a difference between a confidential informant's value or the test or a person who's named, is there not?
No, not in this case. Why? Because Mr. Breyer was stopped. He was unknown to him. And he was stopped and he was trying to bargain to get out of the deal. At this point, he was willing to say anything. And that's why we've had, we've had people that are now subject, we have that in jury instruction. People that are co-conspirators, their testimony should be regarded lightly because they're trying to bargain to get out of their situation. So this person's statements should have been viewed, I mean, it should have been highly skeptical to any issuing judge. But it was implied that he was some sort of informant, that there was some sort of ongoing relationship with him. And the fact that there was not any kind of investigation to verify any of his information, that should have tipped off the judge right then and there. If he had known that this guy was somebody who was just pulled over and was trying to bargain to get out of a potential felony charge. And that's why the good faith doctrine wouldn't have applied. So I'm asking the court, I understand that the good faith in the law on there is not in Mr. Dehart's favor. And it goes right, if I skip all the way ahead, because I know I've only got 3 more minutes left, I want to make sure I hit this point. As I said, he had a huge amount of risk facing him, Mr. Dehart did. And with that amount of risk, when I saw A, how much time had passed, fact, B, on its face, this warrant didn't really seem to have a whole lot of probable cause, and if it did, it was pretty thin. 3 is that Mr. Dehart hasn't gotten in any kind of trouble since this arrest in 2016. 4, he was obviously working on getting clean and sober and he was earning money legitimately through gainful employment, that something should have been tried to be worked out. But when we get those emails that that Mr. Hoffman exchanged with the state, when he said to Bethany Lee, he said trial. She offered to try to work something out, and he didn't even want to. Mr. Hoffman didn't. Yeah, I mean, he said, "I'm not even going to listen. We're going to trial. We're going to a bench trial, not a trial on stipulated facts, a bench trial." Which, I mean, once the evidence is in, it's. I mean, I have no idea what you're going to argue at that point at a bench trial. Even for a jury trial, I have no idea what you would argue at a trial at that point. Right now, your only argument was the motion to suppress, which the court kept reminding Mr. Hoffman he's already ruled. The court already ruled on that motion, and it seemed like Mr. Hoffman was just trying to relitigate the motion to suppress over and over again. And this is what I'm getting at, is when there was a time after the bench trial, see if I can at least salvage something for Mr. DeHart. He files a motion, but not a departure motion, a border box motion, which is totally inapplicable in this situation.
But doesn't he argue some of the correct factors, even though he cited the wrong statute?
Sure.
It was a border box motion. Didn't it still relate to the same issues that you look at for downward departure?
The motion did, but he didn't. Not the hearing. That was a sham. The sentencing hearing was a total sham. He never even got to the arguments and the points that he was raised that were raised in the border box motion. Instead, Mr. Hoffman spent the majority of the time arguing that the motion to suppress was wrongfully decided by Judge Osman.
I thought he added at sentencing that he's talked about defendant's advanced age, the fact he was employed, and he had a low criminal history.
He mentioned it. He never even put in the AA meetings or his NA attendance.
Right.
He never had the witnesses and all the letters that he had presented. But I mean, I'm talking for a departure motion. And I mean, I'm not saying I'm like the ace of all attorneys, okay? But when you do a departure motion, you show up for a departure motion, put on your evidence, put your witnesses on. This is about departure, not about a motion to suppress. That would be something you can do on appeal. Mr. Hoffman forgot all about that. And that cheated him out of effective assistance of counsel. And here he is. He puts up his appeal bond. And he asked for a Van Cleve hearing, which was after a couple of attempts was eventually granted. But we got the Van Cleve hearing. And I've got Don Hoffman who's really sick. And he can't remember anything. But the bottom line is, Mr. Hoffman dug his heels on the motion to suppress to Mr. DeHart's detriment. And now he lost any opportunity to actually do any kind of meaningful plea negotiation and present a meaningful motion for departure, even if it was just a 1 or 2 level drop that was agreed to. Because I know the state wasn't agreeing to probation. So it's not like they were saying, hey, we'll give you probation if you just plea. They didn't say that.
Mr. DeHart wasn't wanting to talk about anything but probation, correct?
That's not correct.
Okay,
That is not correct.
what about that?
And that's what Mr. DeHart was testifying to at the sentencing hearing. He did not authorize Mr. Hoffman to dig his heels in and say, let's go for broke. Now, I've had clients that do that. There are some clients that say, we're not working on anything. Go for it all. I'm gambling. That's not what Mr. DeHart authorized Mr. Hoffman to do. Mr. Hoffman, though, and what Mr. DeHart was telling the court was that Mr. Hoffman pretty much guaranteed him that the motion to suppress was going to win. So he just followed his lead. And I don't know how you could do that, especially with the good faith doctrine hanging over your head. You get a warrant issued. On a motion to suppress with no warrant issued, you got a better shot.
Did Mr. Hoffman testify that he guaranteed him he'd win on the motion to suppress?
No, he did not. Mr. Hoffman didn't even, I don't even know what Mr. Hoffman was testifying to because he was far gone. I mean, he doesn't remember any of these facts of what happened.
But didn't his assistant testify that at the time Hoffman represented your client, that he was not having memory problems or serious health issues?
That's what he said. That's what he said.
Wasn't part of this issue about the communications during plea negotiations that you've raised? Didn't the judge rule based on credibility and rule in favor of the state's attorneys and the state's assistant? Or that was Hoffman's legal assistant and the two prosecutors.
And I think your question is whether or not you could overturn that.
Well, we can't.
Right.
I mean, that's what I'm asking. Wasn't it a credibility call as to that issue?
You know, I mean, I look at that and I think, yeah, there was a credibility determination that the court had to make. But I look at also the emails that contradict the fact that Mr. Hoffman was engaged and never said, hey, I will talk to my client about this. I will speak to my client about plea negotiations. He just said trial. And it baffles me that under these set of facts, that there was never any kind of discussion about, just a proposal that Mr. Hoffman could have made that would have been an alternative to a plea negotiation. Any kind of proposal. And that's why it's obvious throughout all the transcripts and the evidence presented at the Van Cleef hearing when I obtained Mr. Hoffman's file, that he was narrow-mindedly and laser focused on the motion to suppress and only the motion to suppress. And when he lost when the motion to suppress was overruled, he just kept banging his head against the wall, trying to get that overturned.
All right, I've allowed you to exceed your time, but I'll give you a minute to sum up.
Okay, thank you. I appreciate it. I just want to, even if the court does not find that there was sufficient grounds to overturn the trial verdict, at least, it's obvious he never had a meaningful sentencing hearing. He should at least have that under the Bernal case. I know Bernal never even had a motion filed it might as well have been the same thing. There was a motion filed, but never argued. It was not meaningfully. And he never presented his evidence.
Thank you.
Thank you.
Counsel?
Good afternoon. May it please the court. Again, this is Jody Litvin representing the state of Kansas. I'll start with first of all, the state's position here is that following the Van Cleef hearing, the district court rejected all of the 5 issues of the ineffective assistance of counsel claims here, found that Mr. Hoffman was neither deficient and that there was no prejudice. The state's position here is that the district court correctly ruled on all 5 of those issues. If we look at our standard of review, we've got mixed question of fact and law. Our position is that the court's factual findings were supported by substantial competent evidence and that the conclusions of law here were correct. Going to the plea negotiations, since that's kind of where we left off, I do think Your Honor makes a good point in looking at our standard of review and looking at the factual findings, credibility findings that the court made as far as the plea negotiations that were extended, the prosecutor's testimony, as well as Mr. Dunbar's testimony, who was Mr. Hoffman's legal assistant. He talked about how they discussed plea offers on more than one occasion. He testified that the sticking point was the defendant's desire not to serve any prison time. I think that's also reflected in the emails that Mr. Hoffman sent to the prosecutors, and the verbal discussions that were testified by Ms. Lee and Mr. Wenger. The district court found the testimony of Lee, Wenger, and Dunbar to be credible, and that's a credibility finding that this court can't second guess. So I think this court must accept those. They're supported by substantial competent evidence, and that the plea negotiations issue should be affirmed. Moving to the motion to suppress issue, or I can start with any of the other issues if the court has questions. The motion, well, actually, I can start with the motion to the constitutional speedy trial motion. The claim that there's a failure to file one here. Our position is that the defendant did not meet his burden to show that there would have been a likelihood that this motion would have succeeded. I believe Mr. Hoffman at the hearing talked about how he was familiar with the constitutional speedy trial analysis and that he had done claims like that in federal court and that they were rarely granted. And that's, while true, that's not a reason not to file one. Here, the court, although the court went through the Barker factors and eventually determined that even under the Barker factors, that he was not entitled to relief. So there was no likelihood that this motion would have even succeeded. Thus, no prejudice under Strickland as well. The state also alternatively argued that here, the constitutional speedy trial argument wouldn't apply based on sort of the facts that we have here and that it's pre-indictment delay. So the delay that we're talking about here from 2016 to 2018, the 33-month delay, although there was an arrest, he immediately posted bond. And then at some point, bond supervision was ended and the case was pretty much, I mean, it was, the defendant was no longer on bond, no longer arrested, no longer held. And there was no filing done. No charges were formally filed during that time. So our position is the court didn't even need to get into the Barker factors because this pre-indictment delay doesn't count towards the constitutional speedy trial analysis.
But there wasn't any official dismissal of, there's nothing to show that the case was dropped, is there, in the record at that point? It's just sort of like nothing happened.
There's no dismissal because there were no formal charges that
Right.
were filed. So yeah, there's no formal dismissal, but it's my understanding that when a defendant posts bond and there's nothing filed, they get another court date later to come and check in. And then if nothing is filed, then the bond supervision he was pretty much released from bond supervision. I don't know that there's anything in the record other than the record of action that we cited to say that.
But for constitutional speedy trial purposes, we generally do look to the date of arrest, to the date of, so what date are you proposing we use to start the clock here?
I think it's from when, or the state's position would be when the formal charges were filed. And that, I'm not sure the month, that 2018 date. Because there was an arrest here, but it was a probable cause arrest and not, charges were not immediately filed after that. Sometimes charges are filed within that 48 hours after a defendant is arrested on a probable cause arrest. And then we would agree that that starts the clock. I'm not sure that that's entirely clear under the case law, but there are a couple of this court's opinions, unpublished opinions that talk about the time after an arrest, but not formal charging. So our position would be it starts at 2018 at the very least, when the charges were actually filed. And then we did want to point out that the state really, this was presented to the district court below, so we don't really have a preservation problem, but there's no mechanism for the state to file a cross appeal in a Van Cleve hearing. So we would just ask this court to affirm, if this court wants to go down that path, to do right for the wrong reason and affirm on this alternative reason, although there was no notice of cross appeal, because that's kind of an impossibility of the state to do since the notice of appeal was filed so long ago. So it's procedurally kind of interesting, but the state's asking you to, if you would like to go down that path, this court, and not get into the Barker factors at all, we believe you can do so under right for the wrong reason. Alternatively, if this court wants to go down the Barker factors, we think that the district court here did it right in analyzing all of those factors. The length of delay the court did find to be presumptively prejudicial. The reason for the delay, there wasn't any real reason, I don't believe, presented at the Van Cleve hearing as to why. I think the prosecutor testified that she wasn't employed during that time, but it is common that crimes that have person victims are often, given priority in charging over drug crimes. But that was kind of a neutral factor. The defendant didn't assert the right while the case was pending. And then, as the district court found, we would agree that there was no real prejudice to the defendant. There was no oppressive incarceration as he was on bond for that short time. And then there was no evidence presented of his anxiety or concern while waiting to be charged. So if this court wants to analyze the Barker factors, we would ask that the court affirm the district court's decision with those factors as well.
Could you address something he didn't talk about really, but's in the brief about the waiver being insufficient of his right to a jury trial because he answered yes when the judge asked him if he had health issues, I believe.
Yes, Your Honor. That is true that there was a detailed colloquy of the waiver of jury trial, and there was one question that talked about whether the defendant had some sort of mental illness or physical ailment that would have affected his decision to waive a jury trial and go to a bench trial. The defendant did answer yes, and there was no follow-up, and the state has no explanation as to why neither party or the court followed up with that. But when we go to the Van Cleve hearing and what evidence was presented there was some evidence that the defendant testified that he had a heart attack in 2018, suffered from pneumonia and COVID, and had pneumonia during the sentencing hearing. But as the district court found, there was no clear evidence about what specific illness or what mental, physical ailment he was suffering from at the time of the jury trial waiver. And we would ask this court to look at that lack of evidence to show that the defendant really didn't meet his burden to show during the jury trial waiver, there was something that affected him. Even though he said yes, the time to present that would have been at the Van Cleve hearing, and we don't know what that was.
But the state has the burden to show that the waiver was voluntary, correct?
Yes, Your Honor, and we would say looking at it whole, in the total colloquy, we would argue that it was voluntary, freely, and intelligently waived. That right was waived. There was also no evidence that, Mr. Hoffman had tricked him or forced him to waive the jury trial. And I would point to another credibility finding made by the district court in Mr. Dunbar's testimony that there were several discussions of the waiver of jury trial, and that was Mr. Hoffman's, oh my gosh, I'm blanking. That was Mr. Hoffman's decision and strategy as to what they were going to do in this case, which I think is common if you've got a motion to suppress that's denied going to a bench trial, so you can pursue that is not a bad, is a common strategy. So that would be my answer to that, Your Honor.
The waiver is the defendant's, not Mr. Hoffman's.
Yes, Your Honor. We would point to the discussions that Mr. Dunbar had testified about to show that he was voluntarily and intelligently waiving. He had discussions about it. They had discussions prior about the strategy to do this, the waiver. And I think that would just go to bolster the fact that he had been discussing that with Mr. Hoffman prior to the colloquy that was on the record. And as far as the sentencing motion, it's our position that we agree that there was the incorrect statute cited here, and it was a border box statute that was cited and not a true motion to depart with the departure factors in the correct statute. However, if we look at what the district court determined, and if you look at the substance of the motion itself, it really was construed as a motion for dispositional departure to probation. That's what he requested. Numerous factors were listed to support the departure: acceptance of responsibility, longstanding ties to the community, family support, again, the medical problems and the burden that would have on the Department of Corrections, the defendant's performance on bond supervision, and then, as Your Honor noted, at the sentencing hearing, I believe Mr. Hoffman added at least 3 others: continuous employment, advanced age, and low criminal history score. And several of these reasons can serve as a basis for a departure, as the district court noted. And I believe the district court said that it considered this a motion for departure. So the substance of the motion, although it didn't say, really was considered and argued as such. So we would argue that this was really a motion for departure, and it was considered so by the court, and Mr. Hoffman was not deficient in presenting it with an incorrect statute for border box as opposed to the correct statute number. But I don't believe I have any further presentation, but we would ask this court to affirm the district court's findings at the Van Cleve hearing and find that Mr. Hoffman was not deficient and that there was no prejudice in this case.
Thank you.
Thank you.
Counsel?
Thank you. Your Honors, we asked you to reverse the district court's ruling on the Van Cleve, hearing. First, I want to take these in order from what the state was discussing. During plea negotiations, it was never even discussed with Mr. DeHart about what a departure motion would do. So even though he may have said, which Mr. DeHart testified, he was not presented with any kind of plea offers, even though he said he wanted to do probation. Mr. Hoffman never explained to him what a departure motion would do. That's ineffective. Mr. Hoffman, what he was facing, even though he got the mitigated sentence in the box, but he was facing substantial prison time, and now he's ordered to serve 154 months of prison time. That should have at least been discussed with Mr. Dehart about what a departure motion could do in his plea negotiations. I know I never addressed the waiver of the jury trial, and I will say that the state and the court have too easily dismissed that issue. That was, I mean, just to say that, well, we just don't really know what his problems were. You never explored it, and it is the state's burden and the court's burden, especially when he asked the question, and Mr. Dehart affirmatively said, yes, he does have health problems. That should have been explored, and it was on the court, it was on the state to do that, to secure an effective waiver, and they didn't do so. And finally, the argument that the state made that the border box motion was construed as a departure motion is totally wrong, because not only did the state argue that it was the incorrect standard, they actually filed a motion to oppose. And they stated that the wrong standard was requested. Mr. Hoffman never even fixed it after the state filed a written motion saying, Mr. Dehart, in his motion for departure, his border box motion, he's citing the wrong statute. It doesn't apply. And when the state and when the court did make inquiry, he says, all I've got here is just his age and the length of time since the arrest, and it was not meaningfully argued. It was not construed as a departure motion. It was construed as anything as a defunct motion, as a motion that just was defective, and it was not something that that the court could consider in making a meaningful determination about whether or not substantial and compelling reasons existed to warrant a departure. And that's what Mr. Dehart was entitled to, whether he lost all of his motions at trial or whether he tried to work something out. That sentencing motion, especially with what he was facing, should have been effectively argued, and it wasn't. So we asked the court to overturn Judge Osman's decision and find that based on everything, to find that Mr. Hoffman was ineffective and that Mr. Dehart's conviction should be vacated. And if not vacated, then he should be resentenced.
Resentenced or sent back for a new trial?
Well, sent back for a new trial, but if you find that he was effective in everything but the sentencing hearing, then he could go back for resentencing, like he was in Bernal.
Thank you.
Thank you.
Council will take this matter under advisement and issue an opinion as quickly as time allows, and we will do our best to have it out in 60 days.
Thank you.
Have a good day. Our next case is case number 127085 in the matter of the equalization appeal of Plaza Speedway Development Incorporated for the tax year 2022 in Wyandotte County, Kansas. Council, please reflect your appearances.
May it please the court, Wendy Green, Deputy Chief Counsel on behalf of Wyandotte County.
May it please the court, R. Scott Beeler, BEELER, Fritz White Goss on behalf of the Lee Plaza Speedway Development.
Thank you. Are you requesting any rebuttal?
Yes, may I please have 3 minutes for rebuttal?
You may. And you can begin as soon as it's at 12.
If I may, I'll grab a quick drink of water.
You may.
Good afternoon. May it please the court, Wendy Green again on behalf of Wyandotte County. This is a case of classification of multiple vacant properties in the middle of a commercial development known as Plaza at the Speedway. There's a Kohl's, a Sam's, a Walmart. It's just north of the Legends Outlet Mall. And the county has classified them for tax year 2022 as commercial vacant lots, but the taxpayer wished them to be classified as agricultural lots. Article 11, Section 12, under the Kansas Constitution, states that agricultural land should be taxed upon the basis of its agricultural income or agricultural productivity, whether actual or potential. There was no proof in this instance of income or potential income, nor does this agreement that the taxpayer had with Mr. Knott provide any. In this situation,
Wait, I'm confused.
yes,
So the agreement with, for lack of a better term, the
Mhm.
farmer
mhm,
was that he planted the crop
mhm.
for hay, he harvested hay, and he sold the hay and kept the money.
Actually, that's not the case at all. What the agreement was, it was a one-page agreement that said that Mr. Knott would oversee. If anything grew, he would cut, rake, and bale the crop. And that was the end. It didn't say what would happen to anything.
But he testified that he actually sold it.
He testified that he thought he sold some, that there was some that he sold, but he wasn't sure how much he sold it for. There was no receipts provided
But isn't
for
that production?
anything.
If he cut it and even if he didn't sell it, isn't that production?
Production under what that's the main argument that the county is trying to make. Production alone, if nothing happens to anything that is produced, isn't what the Kansas Constitution and 79-1476, that's not the intent of what this law means. Production.
Is it what the words say? Isn't it land devoted to the production of a crop? Isn't that what it says?
It is, but if you look at the rest of the statute, when it talks about how you determine how to tax it, it talks about looking at the actual income
Or productivity?
or productivity
Potential income, right?
or potential income. And the way you determine potential income is what does the landlord, so if there's no crop produced that year, what does the landlord normally produce for this land or lands around it? But there has to be some type of income to even know what to tax this land at. So if all these vacant lands do is just grow some hay and the bales sit there, then there's nothing that's ever going to be able to figure out how do you normally tax these lands? And that's not the intent.
I
The
mean,
intent is to
I've seen
figure out.
bales of hay sit on the side of the road for decades. It just slowly wastes away.
Mhm.
That was productive farmland.
The farmland itself may have been produced, but but maybe it was being used for some other production, not that hay. And that's what the intent of the act of the legislature, and the intent should be for this statute is that something is being done with the production.
But didn't Mr. Kopp say he baled it and sold it?
He testified that he may have sold some bales, but he didn't know how much he sold it for. And the contract itself doesn't guarantee that that will ever happen. And that's what we're stating is, if you're looking at the four corners of this agreement, there is no guarantee that it'll ever be sold. And even if it is, it doesn't say what happens to it. And when you're looking at the case law, like Oak Hill especially says that you have to have, if a lease in itself isn't enough, you have to have the production to go along with the lease. And I understand that later on, taxpayer's attorney may discuss Smith and say, this is exactly like the Smith case, but it isn't. Because at least in Smith, you had a lease that talked about exactly what happens to the production. This doesn't even talk about what happens to the production. And that's the problem that we're getting with, again, we all know what the intent is. This is a commercial vacant land, and the intent is that they're just going to have ag use on it until they do something with it. And that's fine. They can still get this ag use until they find a commercial use for these lots. That's fine. But at least have some agricultural production that looks like actual agricultural production, not just bale it and let these bales of hay sit there until they rot, until you have to bale it again. That's making a mockery of the law and the intent of the legislature to actually have some agricultural production done. And that's what we're trying to
I guess
fight here as the
I'm-
county.
I'm having a hard time defining the difference between producing hay and baling it, which is a product,
Mhm.
and what the owner chooses to do with it after the fact is their decision. It doesn't stop the fact that the land produced the hay.
And that is why we're trying to say that if you look at Article 11, Section 12, and Kansas Statute 79-1476, and all the pertinent parts of 1476, which discuss how you tax it by looking at the income or the potential income or the productivity, that it talks about the income, the productivity and the income of the production are intertwined. Production alone isn't enough. You have to have the productivity, you have to have the income along to go with it. And that's what this court specifically noted, why the distinction of how a vacant lot is important in the Oak Hill case. Because that degree of taxation, whether you have a vacant commercial lot that's taxed at that commercial vacant rate, or you have this agricultural use lot that's taxed at the productivity, is very important, because that's a huge distinction and a huge savings in taxes to the landowner. But you have to still have that income productivity. And that's what the court in Oak Hill specifically looked at, is they tax the agricultural use by its productivity and by its income. Not just the fact that something's produced, but when it's produced, what is its productivity and what is its income?
So if I go out and plant a quarter of ground with Christmas trees that are a foot tall,
Mm-hmm,
and it takes it 10 years to mature,
mm-hmm.
what's the productivity in that 10-year period that shows income?
What they would look at is, what do other Christmas tree lots, what are they able to produce? You are growing it, which your intent is to have a Christmas tree farm. So they would look at, what do other landlords in that area, what are they able to grow, what are they able to sell those trees for?
I understand that, but if I go out and plant seed to grow hay, isn't the productivity of that land, the growth of the hay and then the subsequent, and it later being harvested when it's ready?
If you actually do something with the bales of hay, if you're just going to let the hay sit there and do absolutely nothing with it, then it's not productive.
But it does seem like you're tying productivity to income.
I
But it
am
seems-
exactly.
Doesn't it say the valuation is based on income or ag productivity? Aren't those two different things?
I don't think that it is two different things. I think that what they're saying is, I think they're saying productivity is its potential productivity or income. And what they mean by potential productivity is, if it doesn't have income now, what could it be if it didn't produce this year? Understanding that we're Kansas, we are subject to drought. So if the farmer can't produce this year, what could it produce if it had been a plentiful year of rain? And again, I'm not saying income means profit. Nowhere in the Constitution and nowhere in this statute does it say profit. And nowhere in my brief did I say profit. I said income. And that just means that that farmer or the landholder, somebody is receiving money or services or something for what is being produced on that land. That what is being produced doesn't just sit there and is just being produced for production's sake in order to meet a qualification of a statute. I think you have to go further than just producing something underneath the Constitution and underneath the statute in order to get this agricultural classification. I think that you need to go as far as even further than what Oak Hill Land Company says. And I think Oak Hill Land Company was almost there when it talked about this distinction is important. You have to have, and it's important because it does make a difference in the tax rate if you're going to look at a commercially vacant land and tax it as such, or if you're going to tax it as an agriculturally, as a land that produces agricultural products.
So
Mhm.
Oak Hill, part of its finding was explain some agricultural activity must take place on the land for an agricultural classification.
That's correct.
So why isn't the planting of hay and the cutting of hay some agricultural activity?
That alone isn't enough. And that's what I'm saying is it needs to go further. The case law needs to go further.
But where does the Constitution for classification go further when it says agricultural income or productivity attributable to the inherent capabilities of such land in its current use?
I think because I think is it's not going far enough is in that productivity is income. You can have bales of hay. They do absolutely nothing. They contribute absolutely nothing to agricultural use. Absolutely nothing. They sit there. They don't contribute back to the land. They do nothing. They don't contribute to agriculture if they're just sitting there. If you're just baling the hay to bale the hay so you can meet a statutory classification, it's not agricultural use. And your land isn't devoted to this agricultural use. It literally is just checking a box in a statute. And if you're going to be able to tax this property on its productivity and its agricultural use, have some income to show for it. And if you have income to show every year, have that contract state, this is what happens to the hay. We are trying to make some hay. We are trying to make product that will have a value. Bales of hay that just sit there have no value. And that's what we want the law to go further. We want it to prevent just a mowing contract to get an agricultural classification. It's okay if that's not going to be ag land for forever. That's fine, but do
So
something
you're
more than
saying-
just a
you're
mowing
so-
contract.
You're saying the testimony of is it Knopp?
Mr. Knopp, I think is actually, I think the K is a hard K.
Is not credible.
I'm saying that he couldn't remember how much he sold it for, how much he sold, and the contract is silent.
All right. Your time's up, but I'll
Thank
give you a chance to sum up if you want.
The summary, what I would like the court to remember from the county's position is there must be more than just a bale of hay or whatever production there is from what the taxpayer is trying to accomplish. There must be income. There must be value from what is produced that comes away in order to get this agricultural classification. A mowing contract isn't enough. There must be something in an agreement if it isn't the taxpayer themselves doing the work.
Are you aware that some farming relationships are done by the shake of a hand?
I completely agree. And that's,
So there would be no contract, and you have a contract here.
I do, but this isn't even a lease. This is just a mowing contract. And if it's and a lot of those agreements where, let's say the farmer does all the work on the land and gives part of the proceeds to the landowner and keeps the other proceeds, that's fine too. At least there's value in what's being produced.
Hey, I know I told you you needed, but what's the difference in the value of the land versus the way you taxed it and the way they want to tax it?
It's significant. I don't know off the top of my head what that number is, but I could find it for you before I do my rebuttal.
But the agricultural classification would save money to the taxpayer.
Absolutely.
Substantially. I'm
Substantial.
just curious how
amount.
much we're talking about, because I didn't see it in your briefing.
You're right. I didn't put that in the briefing. It is actually in the record, volume of record. It's in the difference between, I believe it is in the BODA's full and complete opinion where it lists what the county wanted the property value at versus what the final value was. And if it is not, I can have that in my rebuttal for you.
I don't recall it, so okay,
Mhm.
thank you.
Thank you.
Counsel, when you're ready.
Yes, sir. If it please the court, R. Scott Beeler, again, on behalf of the taxpayer. The bottom line here is what you ended up with is why the county's really in front of you. They want to tax this property like some of the similar surrounding area property that has grown up in Wyandotte County. They want to call it a commercial vacant lot, when this property is nothing other than ag land, always has been. Also, it's important to recognize here the standards that we're working under. The case we cited, the Johnson County Commissioners versus Smith case, which the county, I might add, didn't even cite in their brief, much less distinguish, is the seminal case on the law in this area. It is the cornerstone. And in that case, there's a very poignant quote. BOTA exists to decide matters of this nature, and therefore its decision should be given great credence when it is acting within its area of expertise. There is a singular exception to that rule, and that is when BOTA misapplies, if you will, the law. And of course, then this court has full open opportunity to make any corrections that there need to be in the application of the law. So we start here, and I'm mindful of Your Honor's statement about the facts, but I think it's important that we get something out on the table here. Mr. Knopp did in fact testify in an uncontroverted manner cited on page 1 and 2 of our brief that he not only overseeded, but that he tended to, ultimately harvested, ultimately baled, and then sold hay off of the property, and pursuant to his agreement, both written and handshake, verbal, with the true landowner, he kept the proceeds pursuant to that deal, used some of the hay himself in his farming operation, and sold the rest. That's uncontroverted. And we quoted in our brief, actually quotes from the county's attorney on page 2, where she said that is exactly what is happening. As you can see from the photos, we agree that is what is happening. So the facts here really are undisputed.
So you're saying they did have a verbal agreement. There's evidence in the record of a verbal agreement for him to sell or you to.
That is
use the
correct.
hay.
And that was the course of conduct followed not only in 22, the tax year at issue, but 21, 22, 23, 24, and frankly, all the way through today's date, although that's not in the record.
So if he fed the hay to some of his animals,
It's production and it's feed, which is one of the delineated items specifically, not only in the Constitution, but in the statute. I also would like to make sure that we're all aware, yes, we're talking about Section 12 of Article 11 of the Kansas Constitution, which we've all heard now today, says income or production, either actual or potential. So there is literally no factual issue about the actuality of the production. It's, again, it's uncontroverted testimony. The county provided no contract. But in addition to being actual and true income sold by Mr. Knopp to third parties, he then has his own use of it, which in a way is income, could be imputed to him. But in addition to all of that, as county's counsel said, you determine what the potential income is. Even if that's not what actually is happening, she said, you heard her, check surrounding immediate area properties that also produce hay and make a favorable comparison or a similarity. That's how it's done in property tax. Again, the county just wants to ignore the actuality of what was happening here and instead attempt to tax this property as though it's already under development. It probably goes without saying, but if you adopt the county's position, you're essentially saying to any Kansas farmer, if you lose money this year, we can tax you at a commercial vacant rate instead of your ag rate. She's saying it's incumbent that there be income. Your Honor asked a very poignant question about the Christmas tree farm. Well, at what year is it that we stop the clock? You threw out 10 years, and she said, well, no, if you're actually intending to sell these Christmas trees, then it's production and there will be income. But what if you don't sell them at year 8 or year 9 or year 10? What if it's year 20 because you're looking for, the mayor's Christmas tree, whatever it may be? Those are standards no one could ever follow. The issue is here, what really is the property being used for?
Well, it's unusual, when you have a written contract that talks about mowing, that you would have a verbal agreement to also sell the proceeds from what you mow. Why wouldn't, if that's truly what was intended by both parties, why wouldn't all of that have been encompassed in the written agreement?
Well, number one, the county has no standing to challenge the private written agreement between third parties. That's never going to be an issue. But to answer your question directly, it isn't a mowing contract. That's a characterization.
It
It's an
seemed accurate
agreement.
to me.
I'm sorry.
It did seem accurate to me.
All right. Well, what I'm saying is you don't overseed year in and year out if all you're doing is mowing. I've stopped mowing my lawn some years ago. My lawn man doesn't overseed. He comes and mows. If I want overseeding or something else, I do it myself or I have it contracted. So we're talking about a process, an agricultural process. You overseed, you tend, you fertilize. When the time is right, you harvest. Okay, it's not mowing every week. It's a one-time harvest of a hay crop, a crop, as it's commonly referred to. It's then not left laying in the field. It's baled into a commercial way of distributing the hay and then sold or used, moved for feed and farming operations. That's what happened here.
But it's not what the contract said. The contract said nothing about sale.
It did not. What it did say was the harvest, the overseed, the baling,
The rest of
and
it.
the harvesting.
Right.
So yes, they could have said the word sale, but as I indicated, there's a long course of conduct that is, again, undisputed. It's an uncontroverted fact that they did, in fact, sell this hay or use it. It did not sit on the property. This is a 18.72 acre property. The Smith case was a mere 2 acres. And the court made very clear to say there, it doesn't matter what the size is. But I can assure you, if all we had was 18 acres of hay that never moved and was in 1,000 to 2,000 pound bales, as hay is, when you bale it this way, you'd have nothing but a tower of hay bales in this property. This property is clear. It's cleared every year by this exact process. So there really is none of that. But the Smith court made very, very clear the test is not economic viability. It said it is also not the use of nearby properties, which is again what the county is trying to throw a cloth over here. And it's most certainly not even the potential future use of the property, i.e. as a commercial development or otherwise. And lastly, it isn't tied to profit in any manner. Instead, they say, and they quoted, what use is being made of the land is the test. And here, it's uncontroverted testimony that the use of this land has been throughout this period of 22, but before and after that, devoted to the growth of hay, harvest of hay, and in that productivity.
What was it taxed at in 21 or 20?
I, like counsel, would have to look that up. I don't know if she's found that yet, but,
No, but not the.
oh, well, ag,
It was taxed as ag
Ag.
before 22.
yes.
And then
The
they
county,
changed the valuation. of
correct, and
22.
my client appealed that to
Okay, so
BOTA.
this is the first year.
It was the first year of the change.
All right. And has it been continually taxed as commercial property under
I
protest?
believe that is correct. She can correct me if I'm wrong, but my client is challenging the first year of the change and would challenge any year thereafter. and ask Boda to make the appropriate adjustment. In my last, I have extra time. I don't intend to take it all. But the county cites, again, the protest of Oak Hill Land case. And number one, that case is very easily and clearly distinguishable. That's a forestry case, sort of goes to Your Honor's example. There was a lease or an agreement, a contract, whereby a party stepped up and said to Boda, well, we're ag because here's our contract that says we can grow and harvest trees. Well, the evidence, though, again, what is the land actually being used for? The evidence at the hearing was no harvesting. There was no program. There was no schedule for harvest, as often is the case. So the clear facts were there was an attempted dupe on the county in that case, whereby they could call themselves ag when they never had actually done anything to produce. The actuality of growing and harvesting anything did not happen. So it's a complete inopposite to the facts that are here before this court. And there was no agricultural use that was actually pursued in the Oak Hill case. And as I mentioned, on a very small parcel, the Smith case, what I again call the seminal or cornerstone case here, that was based upon income or production, actual or potential, was on a mere 2-acre parcel, growing hay, overseeded, harvested, and baled. Again, the terms of the private agreement between the parties was not at issue there, and I don't believe it should be at issue here. In any event, we certainly know that the landowner here has never objected to the way the hay has been dealt with. In fact, they have allowed this process, this agreement is an annual agreement. So it continues year upon year in the same manner that I've described it to you without any objection of the landowner. So with that, we're asking you to affirm the decision of Boda in this case and allow this property to continue with its classification of agricultural. I'd be happy to answer any other questions the court may have.
Thank you.
Yes, sir. Thank you.
Thank you. May it please the court, Wendy Green again on behalf of the county. I could not find the actual value difference between the commercial taxation and the agricultural, but I can tell you that 2022, the year at issue, was the first year that the agricultural classification was that they asked for the agricultural classification and the county denied it, which is why we are here. And Boda upheld a agricultural classification and asked the county to change it from commercial to agricultural. Before that, it had been classified as commercial along with a lot around it that had been developed. I'm sorry, did you have a question?
No.
Okay. It is surrounded by development. There are roads on either side of all of these lots. So they are ready to be developed.
So is this, I guess I do have a question.
Mhm.
Are these lots north of the Walmart?
They are north of the Walmart, in between the Walmart and where the, right, well, actually, they are north. No, they are south, east of Walmart, but southwest of Sam's. They are in between the Walmart and the Sam's
Okay,
and just south, but they are north of Parallel.
all right.
So they are in between the developments there, just north of Parallel. So they have developments on either side, and they're in that development known as Plaza at the Speedway. So there's development all around them. They have the infrastructure there. So they were commercial, taxed as commercial until 2022, when it was asked for them to be taxed as agricultural. And to correct counsel, in the testimony that we had at the hearing, I did make a statement, and it is in his brief, that I did agree that, and that was the quote, that I agreed that Mr. Knott will oversee the property and bail it once a year, and that was in the agreement, but there was nothing about the hay, that he would actually do anything with the hay, that he was selling the hay, that it was in the agreement that he would do anything with hay, because it's silent. That contract is silent. It is a mowing contract. And as we have been asking for, we believe there's got to be more than just producing a bale of hay. There's got to be some income.
But as I understand, you agreed that he actually baled the hay from the pictures that were exhibited.
Yeah, there was evidence presented that there was a bale of hay there, correct? What we said was it's silent as to what happens to the hay.
Are
and
we saying
has
there's
to be
a
something.
bale of hay or a bunch of bale of hay?
There was bales of hay on each of the lots, correct? hmm That was the evidence presented, correct? There was bales of hay on each of the lots. And that was a fact by the board, and we know it's hard to dispute the facts. But what we are asking for is make there be more. We believe that the constitutional provisions and the statutes require more than just the bale of hay. It requires that something be done with that bale of hay. That agreement should state what happens with the bale of hay, and that hay has to be produced. This agreement is silent. It's, the agreement calls for the overseeding. And then it states, now, if there's hay, then we would like for you to mow it and rake it and bale it. That's why there's two different fee structures involved. There's one fee for the overseeding, but then there's a whole other fee structure if something actually happens. And we're not stating that there has to be a profit. God help our farmers if each of our farmers in the state of Kansas had a profit every year. That would be great. But that's not the case. That we're not saying income equals profit, because it doesn't. And it doesn't say that under our Constitution or in our statutes. We're just saying there has to be income. There has to be some type of exchange. These bales of hay have to be used to do something. They have to be sold. There has to be something further that happens with the production. There has to be some productivity.
But didn't the Mr. Dopp say he fed it to his cows or pigs or horses or whatever?
That actually isn't, I don't believe he testified to that. He said he might have sold some bales, but there was no evidence as to how many he sold, what he sold it for, and does he do that there wasn't that type of evidence on the record. He said he thinks he sold some bales, but that wasn't any evidence there was no documentation as to what happened to the actual hay. And that's what I'm saying. And the contract itself is silent. And the fact that the contract itself doesn't even require anything to be grown. It just says, it's almost let's hope and see if we can actually produce something so we can check the box under the statute and get the ag. And that's why I'm saying, make there be more for them to get this ag classification, because it is a huge difference under our tax code. Make there be more. And that's what the county is asking for. Thank you.
Thank you. We will take the matter under advisement and issue an opinion as quickly as time allows, and hopefully within 60 days.
Thank you.
Court's adjourned.